Both of them have scandalized the court. NDC was the president. Both of them went to jail. NDC used Article 72 to remove their people so that they didn't serve the full sentence. This morning, the quorum was led by Justice Amadou Tanko, who presided, Justice Ernest Jehu, who dissented. He felt that the warrants should not have been vacated in the manner that it was done. We are eagerly waiting for the reasons, and then we will treat Justice Jehu's dissenting opinion in some great detail. And then there was Justice Philip Bright Mensah, who decided that the warrants should be vacated. It doesn't matter because the reasons they gave. We're waiting also for their reasons. And then there was Justice Simon Subari, who also was part of the four. I think it's finished. And this is Justice Senyor Jamefe, who was also part of it. This is what happened today, and this is our small commentary on it, that this is not the way we should build our democracy, because what has happened means that my friend Abronye will scandalize the court. He can say anything about the Supreme Court. And then they'll issue a warrant, and then he'll come to court and say, I have a certiorari. Because today, they were citing Kennedy Japan. That, Kennedy Japan too scandalized the court. Didn't he scandalize? And then they went and then they removed him. So Abronya will come and say, na Kennedy Japan scandalized court. Kevin Taylor scandalized, and then the confusion will start. A court will say they won't give certiorari. MPP will put people on the streets. Police will shoot at them. And then we are turning it upside down. Because these days, with power of media, gun doesn't win. Gun doesn't go anywhere. You shoot, look at Togo, they are in crisis. Look at Ruto in Kenya, all over the place. Gun doesn't go anywhere. So Abronya will go and do that. And then he knows what he's doing. He is sure about what he's doing. Then they'll go and catch him and take him to a Kumasi High Court. And he'll say, you won't go. You won't go. Then he'll bring certiorari to the Supreme Court. And the Chief Justice may or may not list it. I don't know. Or he lists it and then the certiorari fails. And then the MPP say, hey, why is the certiorari failing? When this one? And then they say, today, then we are going. They are in opposition. They don't have much work to do. They are looking for something. And then they charge in Kumasi and put 1 million people on. Kill them. And let's see. And whose fault would it be? Whose fault? Whose fault would it be? Okay, go. Please come. No, hold up. Is here. He can come. He can just come. So, come, let's do it. We don't have much time. We run away. I like your outfit, man.
Thank you.
So you were in court this morning, very briefly. What happened?
So the court ruled. So initially, when the party, that is Kevin Taylor and his lawyer, the Leonard Peter Okujeto, were in court, the Attorney General's Department did not appear. No, the picture of the Supreme Court, please.
Yeah, that's the Supreme Court. He wants the Supreme Court building. Okay.
So the lawyer, the states, the Attorney General's Department, no representative came from the Attorney General's Department. In fact, Justice...
No one.
That is so. I mean, there were lawyers from the Attorney General's Department for other matters, but not specifically for this one.
So the Attorney General was not represented?
Yes. And indeed, I remember Justice Amadou Tanko insisted and said that everybody must see that indeed the Attorney General's Department was saved, and they did not appear. Indeed.
They did not appear?
Yes, there was no representative.
But they can do that? It's easy to do
well, that? Well, you may, but it would be best to
but
at least appear and tell the court, exactly,
yeah.
appear and tell the court that we have no interests opposing the motion, but not to appear. But maybe somebody was also assigned, maybe the person could not make it, and so we cannot really jump the gun and make conclusions. To be quite unfair to them. And so the decision was handed down, and we do not have the full complement of the judgment of the ruling yet in respect of this matter. But it would seem that the main arguments the court was making was that the procedure is that the courts must first make what we call a summons. The summons, as we discussed earlier, the summons is directed at the person to attend court and show why he should not be placed in custody. The argument that actually erupted after, and in fact before, which we discussed here earlier, was that the summons operates in this instance also as an arrest warrant, in the sense that the arrest warrant is to show cause why he should not be committed.
So when such a person is arrested, he's not being taken to jail. He's being taken to
brought
court.
To court to show why he should
to the same court that did the warrant.
Exactly, why he should not be thrown behind bars.
And he can make arguments.
Yes, he can make arguments. So he can beg. He can make a constitutional argument. In fact, I even believe that, that's my opinion, Kevin Taylor should have gone before Chamber 4 and
to withdraw.
To not withdraw, but even make the argument that the power of contempt, the ambit of the power of contempt, there should be the Supreme Court should have interpretative guidelines for the exercise of the power of contempt.
That is too broad.
It's too broad, it's too vague, so that there could be some jurisprudential discussion, and then upon that we go to the Supreme Court for a determination. But we have missed out on that opportunity because... But
maybe he was worried that if he appears before Chamber 4 will say, I don't agree with you, go to jail.
Well, that is one way to look at it.
But somebody was telling me that the other way to have gone about it was that I bring him before Chamber 4. Whilst he's standing there, his lawyer informs Chamber 4 that the certiorari application has been filed at the Supreme Court against you. Can you stay and let's hear the certiorari application? And then the application is granted, and so Chamber 4 knows that would have been, I mean, they use certain words.
The purpose of so the thing is that the arrest warrant is directed at law enforcement agencies to procure someone's attendance. And so the arrest warrant in and of itself is not a process or a procedure that goes on in courts. It is directed at the police. It's more or less an order of the police.
To go and bring this guy to the court.
Exactly. Yeah. A summons is directed at an individual to appear. Unlike the arrest warrant that is directed at the police
to go and get him.
To procure the
that they found him.
Yes. So the legal principle, if you and I litigate over land and the court gives you judgments and the court says that you are the winner and therefore the land is yours, I cannot say because I disagree, I am not complying with the order of the courts. Till that order is set aside. It is the law, and it is what's supposed to stand.
So those persons may, if it's true that happened, they may have questions to answer.
Exactly. But the thing is that it is the state that ensures these things are followed through. But it seems the state also did not appear in this instance for whatever reason. So we are waiting for the full reasons of the courts in respect of this issue to make a full and comprehensive analysis as to why the courts ruled in this manner. But I'm sure it's an issue of maybe a view of technicality against intent or whatever. I don't think maybe the courts would have.
There's a matter that I have to bring to your attention. It's been on most of the NDC platforms. They said that Kennedy Japan. There's another article that says Kennedy Japan's own was completely different. Kennedy Japan scandalized the court by attacking a judge. A judge issued a warrant. He went to the Supreme Court on the basis that the judge did not ask him to come and defend himself. The position of Kennedy Japan's lawyers was that Kennedy Japan is a member of parliament and you know where to find him. So the judge should have issued it on parliament that produced Kennedy Japan, and they would have done so. But to go ahead without hearing him and do that, and that's the decision the Supreme Court took. So they are thinking that it's on all fours, as the lawyers say, with this one, and there's a lot of disagreement on social media.
The issue of
that in this one, there was no way to serve him. He was not going to be willing to come. So it's clearly different if you issue the arrest warrant. You know.
The issue of service, particularly for MPs, is that there is a specific way MPs are served. So for me, if somebody wants to sue me, the person can meet me, can come to my office at Adabraka and give me a show wherever. I'll come here on my way home. But MPs, it's different. There are days they are supposed to be served. In fact, in Parliament, there are officers that can receive processes from the courts on behalf of MPs. And the rationale is that the job of Parliament is very fundamental. We were all in this country when the D levy was passed at 11:30, 12 a.m. And so the nature of Parliament is it is standing for the 4 years. There are times here...
So every minute he's in Parliament?
Every minute...
he's deemed to be doing parliamentary work.
Either exactly, going to or from. Even the act of parliamentarians going from place to place, talking to...
It's all deemed to be part of parliamentary work.
Parliamentary work is not just sitting in the chamber and saying, yeah. And so the rationale behind that can be said that there is a format, and we all know the position of the law in the NTHC case, that when the law lays down a specific process for doing something, it is that process that ought to be followed. In this instance, Kevin Taylor is not an MP. There is no specific instance for procuring his attendance. There's no specific process for procuring his attendance. In any case, the other side may also argue that in any case, it is still the same thing, that the summons must have been issued, and then upon him failing to attend courts, the arrest warrants, because the issuance of the arrest warrant also puts makes him a sort of pariah. People begin to say, hey, now you arrest warrants. Well, sooner there's an arrest warrant on you, and so the court should have afforded him the opportunity to attend, and then upon failing to attend, then he would the courts could.
So those who now want to sue Kevin Taylor and those who have sued him already and obtained judgment, is it good news for them? Is it better news for them than that he's not available?
It's not. Well, he has to be saved. he has to be served. And if his location in Ghana cannot be found, they can attempt service 3 times. If they attempt service 3 times, they can apply for what we call substituted service, where he can be served through WhatsApp, he can be served Facebook, posting notice on the walls of the high courts, the notice.
So you post Facebook and tag him.
Yeah, you can post on Facebook and tag him.
And then the trial can start.
Exactly.
It will be assumed that he doesn't want to participate.
Exactly.
Then you go and get a judgment.
And then
whenever you can enforce it against him.
Exactly. You do what we call entry of judgment, where you detail the amount of money that has to be collected from him. And then you also attempt service of the entry of judgment. If still the process, you do it 3 times, you come for substituted service, it is posted, and then it can be enforced. However, if he is not in the jurisdiction, that is also there's a different procedure for instituting actions against people that are not in the jurisdiction.
But given that he's not ordinarily resident here, he may not change that. Is he now to be considered as in the jurisdiction or not?
Yeah, he's a Ghanaian citizen, and he lives. Well, I won't say he lives here, but
he has been here to seek legal process, legal redress.
Yes, and he attended. In fact, if those who were going after him may have suspected he would have been at the Supreme Court, they could have been hiding at the premises. So immediately
I think you heard the conversation between me and another lawyer who said that he just got there and then the Prado took off and he'd taken the number of the Prado and he's doing something.
He should have sat on an Okada and chased the Prado.
He said he just got there and the Prado took off. He was just going to get the bailiffs to arrest the Prado that he was using so that national security will beat them up and then we can have a story.
Maybe the lawyer is a gentleman. Someone would have sat on an Okada and chased the Prado because once he leaves the court premises, how are you going to find him again? And in our jurisprudence, service is so fundamental.
Yeah.
If you have not served a process on a party, the courts can say, I do not have jurisdiction to.
But here you can do substituted service.
Exactly. That's it. So, and even the substituted service, there's a threshold. You have to attempt service 3 times.
At least 3 times.
Show the court at least 3 times.
So that you are unable to reach him.
I'm unable to reach him. And any future attempt
will be futile. Yeah.
Exactly. And then the court would give
because he would have left Prestige Link and gone back to America or gone to
I don't know if it's at #1 Prestige Link, but that is what is in the.
I heard they are doing party. They are doing party today.
Oh, thank you very much. You are victorious. You have to celebrate.
Thank you.
My life is in stages.
Intim Fojo is here, and let me talk to Intim Fojo. But whilst I do that, please give me 2 text messages each if you can. Did I leave my paper over there?